Good morning, ma'am. Are you Glenda Williford?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Give me just a second to get that pulled up.
Our agreement, Your Honor, is for her to go into special needs safety.
Thank you. Sorry, it's taking a minute for my computer to get pulled up here.
This morning, Your Honor.
Okay, so Ms. Williford, in cause number 24 DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred.
Pause here. This is critical. Deferred probation means she avoids prison for now, but the felony is still loaded in the background like a safety-off trigger. One serious mistake and the judge can sentence her all the way up to 20 years. Would you feel safe walking on legal thin ice like that?
Probation, is that correct? It alleges that you violated your probation. Count 1 alleges that...
Judge, we've agreed to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true?
This is how probation really collapses. Not with one big crime, but with small violations stacking up. Failed drug tests, missed programs, unpaid fees. On paper it sounds minor. In court, it's a countdown timer to prison.
Or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today, and is that the recommendation from probation as well?
Yes, ma'am.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
There you go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. It looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year.
That wasn't a warning, that was a legal ultimatum. One more slip, and the judge can flip this case from probation to a felony prison sentence instantly. Second chance granted, final chance issued.
And this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
had a statement prepared for you, explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never.
You can feel the panic here. She's not arguing the law anymore, she's begging for mercy. But courtroom reality is brutal. Explanations don't cancel violations. Do you think the judge should consider her health, or stick strictly to the rules?
Touch this shit again if you let me go home.
Are you seriously going to stand here and talk
No.
like that?
No, ma'am, I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I would get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to.
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff. Trial and figure out whatever to do on that state jail later. All right, sir, you're John Jones?
Yes, ma'am.
Give me just a second. Let me get your, everything pulled up here. See, Mr. Jones, in cause number 25 DCCR 0523, you're charged with a first-degree felony offense of murder from April 28th of 2025. Sorry, blunt one. And what that means, sir, is that if you go to trial and you're found guilty in that offense, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand the range of punishment?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with a state jail felony offense of unauthorized use of a vehicle from October 15th of 2024. What that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in the state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1352, you're charged with a first-degree felony offense of aggravated robbery from September 18th of 2024. What that means in that case is if you go to trial and you're found guilty, the range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in clause number 25 DCCR 1353, you're charged with the second-degree felony offense of robbery from September 18th of 2024. And in that case, what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then I have here on the tablet, in those cases, some plea bargain rejections that you've signed with Mr. Wilkerson. They show that the district attorney's office has made an offer, if you wanted to enter pleas of guilty, for a 35-year term in the murder case to run concurrently with a 35-year term in the aggravated robbery case, with a dismissal in the robbery as well as the state jail felony unauthorized use. Is that correct?
Yes, ma'am.
Do you understand what their offer is?
Let that sink in. 35 years offered. And he says no. That's not confidence. That's a gamble with the rest of his life. If the jury convicts and the sentences stack, this could quietly become a life sentence.
Yes, ma'am.
And have you gone over it with Mr. Wilkerson?
Yes, ma'am.
And do you want to reject that offer and have all 4 of your cases set for trial?
Yes, ma'am.
All right. Is there any reason to expect that those offers would change any evidence that you're waiting on that you guys haven't received or gone over?
No, Your Honor, not at all. In fact, the state will be, will likely be filing a motion to accumulate the sentences to the extent that we can. I think 3 of them would combine one occurrence, and then there's one from a separate occurrence.
You've actually got 3 different dates. So you've got ag robbery and robbery from September of 2024. You've got an unauthorized use from October of 2024, and then the murders from April of 2025.
To the extent we can accumulate all of those, Judge, we will seek to do so.
So I want to make sure you understand, Mr. Jones, that if you are found guilty in more than one of these offenses by a jury, the state can file requests that I stack or run cumulative, which means stack on top of each other any punishment that you receive. Do you understand that as well?
Yes, ma'am.
And that after today, I will not accept this agreement for a 35-year term. If you change your mind later, you can enter a plea open to the court. You can enter a plea to something different, but it's not going to be 35 years. Do you understand?
Yes.
All right, and do you want to have all of your cases set for trial?
Yes, ma'am. I got a question though.
Yes, sir.
It's my offer 35, right? Like that's what the DA's offering, right?
Uh-huh.
My co-defendant admitted to it, but he got a 30-year off.
Here's the thing. Your offer is what your offer is. He may or may not have had the robberies before he would, listen, I don't know. I know the offer is what the offer is. All right? So either you take the offer or you go to trial and let a jury decide. I'm not involved in negotiations. I'm not going to tell the district attorney's office what to do. That's not my job. But you don't get to, everybody has different issues in their cases that they feel important and why they would make different offers for different co-defendants. All right? So you're not going to have a different offer, and that's what I want to make sure you understand. Even though there was something different for your co-defendant, the district attorney's office has said, this is it, this is your offer. Do you understand?
Yes, ma'am.
Okay, and you want to reject it and go to trial?
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Wilkerson will begin preparation. You can go back with the bailiff.
Thank you, Your Honor. Be excused.
Thank you, sir. For entered pleas of guilty in cause numbers 25 DCCR 1106 and 1108 to the first-degree felony offenses of aggravated robbery. The agreements were for 10-year deferred probation and $500 fine in each. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor. I have, Your Honor.
Are there any additions or corrections?
Not from the defense. No, Your Honor.
So, obviously, Mr. Briones, this gives me a lot of concern based on the nature of these offenses. Another thing that I make notes in your pre-sentence report, and one of the things that I have found continuously happening in cases with young people your age, you're 18? Okay, so everybody says they're hanging out with the wrong crowd, right? But everybody can't be hanging out with the wrong crowd. You've become the wrong crowd, right? And so if I give you this opportunity today, then this is the best opportunity you will probably ever get in your lifetime, because you will be able to live your life, hopefully, in a very different way than you were on that night, and the way you were going down that road as a juvenile with stealing cars, right? Why didn't you finish school?
Because I kept being sent to the alternative campus.
Because you kept getting in trouble, right? So part of your probation is going to be that you get your GED, and you're going to get it soon, because that's hopefully you should want to get that, because it's going to help you be more successful in life, but it's going to be a part of your probation. You understand?
I'm in the program already. It's just waiting on me to go.
Okay. And I know that ISF Cognitive was not a part of this plea agreement, but that is what's going to happen today as well, and I'll explain that more. I'm going to find, Mr. Briones, that you entered your pleas of guilty in each of your cases freely and voluntarily. Find sufficient evidence to find you guilty. In cause number 25 DCCR 1106, follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, and I'm going to go over some of those in just a minute. And cause number 25 DCCR 1108, also find sufficient evidence to find you guilty, but follow the agreement and defer all proceedings and place you on probation for 10 years. You're also ordered to pay the $500 fine and to follow all of the rules and conditions of probation. One of those conditions in each of your cases is that you will enter and successfully complete the cognitive track of the ISF program. That is a 90-day program. That is, you'll go from jail to that program. And it is a program where you receive tools to help you make better decisions. You're young, you're going to have to be making very adult decisions if you're going to keep yourself out of prison, and that's going to help you do that. So what that means is if I give you that up front and those tools up front, and then you get out and you violate your probation, there's no coming back and saying, oh, I need a second chance. This is that chance. You understand? Also, a condition of your probation is that you have no contact with Deshaun Vital or Vital, however you say his name, the co-defendant. Obviously, you have no contact with the victims, Leandre Collins and Peyton Mahan. And you're not allowed to possess a firearm at all. Even though you're not convicted, you are not allowed to be in possession of a firearm. That means in the house you live in. So if you live in a home and other people have guns, they have to have them either locked down or out of the house. And probation can come check on that and make sure of it. And if you're caught where there's a place where there's guns, that's a violation of your probation. Can't be in a car with them. You can't have them anywhere. You understand? And so if you do everything that you're supposed to on this probation, again, this is an excellent opportunity because you don't have the felony convictions on your record. And you will be able to, at the end of the probation, if you're successful, have these cases dismissed. And you'll never be.
This is the Courtroom lottery ticket. 10 years of perfect behavior and his record disappears. One violation and he becomes a convicted felon facing life in prison. Freedom or forever, decided by everyday choices.
Convicted felon. The other side of that, though, is if you violate any condition of probation, you're brought back in here, found guilty, so you're then a convicted felon, and I can sentence you to prison anywhere in the range of punishment, which is up to, I think, first or second.
It's a first year.
So it's up to the rest of your life. It's between 5 years minimum in prison, up to the rest of your life in prison. That's what's hanging over your head. So you have to grow up very quickly and make good decisions like everybody else that's not in prison, or else you'll end up there. You understand? I'm handing you the trial court certifications in each of your cases that shows that these were agreements that I followed, and so you've waived your right to appeal, and so you can go back with the bailiff. All right, good luck to you, sir. Let's
Thank you,
see.
Your Honor.
Thank you. Burton, Bailey, Mr. Rojas.